Today, January 15th at 7:30 p.m. Again, just as a reminder, the sign-in sheet is at the end of the table. We would just ask that you, again, in addition to your name, also put your address. And then when you come up to speak, again, it'll be 5 minutes. Any council present on behalf of any group or groups, council will have 10 minutes. So that having been said, I think my preliminary remarks are pretty consistent from the hearing 1, 2, and 3. So again, you're here hopefully to give us additional comments and any thoughts and suggestions with regard to the House of Worship law. I am advised that as we speak, there's actually one attorney here representing a group. So, Mr. Mogul, you get the honor of starting things off. And again, name and address for the record and the organization you representing.
Hello? Okay, very good. Stephen Mogul. I'm representing Coupon of Chestnut Ridge. My address is 457 Broadway, Suite 16, Monticello, New York. I've now appeared in front of this board several times on this proposed law. I've pointed out at every appearance that Coupon of Chestnut Ridge believes in the founding principles of this nation, of which the freedom to worship as you please is rightfully and properly one of the most revered and protected rights that we enjoy as Americans. And that as Americans, we have an absolute right to live wherever we please, regardless of religion, race, color, etc. However, at my prior appearances, I have pointed out that this law was born in sin. It was crafted at non-public meetings wherein only one religious group, the Orthodox Jewish Coalition, or OJC, and their engineering firm, Brooker Engineering, was invited to attend, and no minutes, notes, or even attendance records were apparently taken. This law was first presented to the public at the village board meeting on February 22nd, 2018, on less than 2 days' notice. Even though a memorandum was prepared with the draft law and was presented to the village board almost 2 weeks before, on the 9th of February. But that's only a tiny piece of the story that the public has not been told about the drafting of this law. Coupon of Chestnut Ridge made a FOIL request requesting the invoices generated by the village's planner for its work on the House of Worship law. The documents produced by the village revealed that the OJC, the Orthodox Jewish Coalition, provided a draft House of Worship law to the village before August 15th of 2017. How do we know? Because Nelson, Pope, and Voorhees, the village's planner, first billed the village for 2.5 hours of work for, quote, reviewing OJC draft zoning, arranged meeting, on August 15, 2017, and that invoice was paid. There were 3 more items billed to the village in August and early September of 2017, including a 3-hour meeting with the engineering firm hired by the OJC that was held on September 6th of 2017. All told, the village's planner billed 11 hours in August and September to the village on the OJC's proposed House of Worship law. Yet the first time the general public heard about this proposed law was 2 days before it appeared on the February 22nd, 2018 village board agenda. It was 6 months after it was first reviewed by the village's planner. I have copies of the invoices if the board is interested. Of course, we have to presume that the village planner didn't start its billing for its review of the law without any direction from the village board, or at least the mayor. So it is undoubtedly true that this board knew of this proposed law considerably more than 6 months before it was revealed to the public. The impropriety of this process, which has never been adequately redressed by this board, has been called into question not only by Coupon of Chestnut Ridge and individual members of the community, but also by the village's own planning board. I don't believe I'm alone in stating that the board members' actions in crafting this law and in the members' attitudes and statements throughout this process conveyed the distinct impression that the board made up its mind to pass this law long before the general public ever knew that taxpayer dollars were being spent to review it, no matter what good planning principles are violated or environmental, legal, or quality of life concerns are raised, and over the objections of many or possibly even most of the members of this community. This tainted process is not the primary objection that Coupon of Chestnut Ridge has to the proposed House of Worship law. We've set forth substantial evidence of the potential significant adverse environmental impacts of the proposed law, impacts which have also been raised with concern by the village's own planning board, and now, despite it being in a substantially watered-down version, from the village's planner in their October 26, 2018 memorandum. I've detailed in my prior appearances how this proposed law is not in compliance with New York State and statutory and case law, in that it's a dramatic departure from the village's existing comprehensive plan. The observation that this proposed law is a dramatic departure from the current comp plan is shared by both the village's own planning board and the village's planner. I emphasized that the village's planning board recommends addressing this issue within the context of an adopted comprehensive master plan. I pointed out that I did an informal survey of the 19 villages and 5 towns in Rockland County, and as far as I could determine, there are only 3 villages with existing House of Worship laws, and of the 3, 2 passed their House of Worship laws after preparation of a formal adopted comprehensive plan. I've directed the board's attention to the reports of Alan Sorensen, a professional planner whose most recent report concurs with the position taken by the village planner that the, quote, proposed action is not consistent with the adopted land use plan, and that, quote, the proposed project is inconsistent with the existing community character, and that significant adverse impacts may occur in the area of transportation. Mr. Sorensen also points out that there will be profound impacts upon land, surface water, noise, and light. I have a copy of the report, but I'll hand that out after I'm done with my comments. Ms. Kogut will provide a synopsis of Mr. Sorensen's report upon the village planner's proposed FEAF Parts 1 and 2. Nevertheless, this board pushes through this legislation, claiming in part that it has no choice because of the demands of our LUPA. Coupon of Chestnut Ridge has prepared a white paper on our LUPA that we're now submitting into the record. Again, I'll hand that out after I'm complete with my comments. In sum, the white paper demonstrates that the cry that this law must be passed or else the village will face an Arlupa claim is a red herring. This law is neither mandated by Arlupa, nor will it insulate the village from suit under Arlupa. Thank you very much.
Thank you, Mr. Mayor. Next is Mr. Paley, Richard Paley. And again, as a reminder, Mr. Paley, just for the clearance, for clarity of the record, your name and address, please.
Richard Paley, 17 Lancaster Lane, resident of about 20 years. And I'd like to present a vision of 2 different paths that the village of Chestnut Ridge could possibly take. And as a prognosticator, perhaps it's good to give you a little bit of background and introduce myself to the people that are here in the way of credentials. My background is in low and middle income housing. I owned and operated at one point 2,000 apartment units in Inwood, Marble Hill, Washington Heights, parts of the Bronx. I also authored a plan of low-income condominium housing for the city of New York, presenting it to Commissioner Matthew Domber, Housing Commissioner under Mayor Wagner. That may date me a bit, if anybody remembers those names. That later became the basis of the FHA 221D3 program for low-income condominium housing. I did this pro bono. It was voluntary. I wasn't looking for monetary compensation for it. And together with Cora Walker, a well-known black attorney from Harlem, she and I were instrumental in renovating a whole square block, about 137th Street and 7th Avenue. I was a board member of HAR-U Act, which was a foundation for uplifting that neighborhood, formed by Livingston Wingate and Adam Clayton Powell, another old name here. So I've also served on the boards of the Institute for Specialized Plastic and Reconstructive Surgery and a number of other boards, etc. So the vision of where this village could go is, one, if the advocates of the change of zoning law have their way and this board approves it, they shall live in infamy. That shall be the legacy, because vision 10 years from now, 5 or 10 years from now, what will this village look like if this law is put forward? Congestion, how many places of worship, the taxes that will go up because of the default in taxes because of the strange laws about houses of worship, and other pictures which others have presented here much more graphically than I, and I won't have to go that route. On the other hand, if the same board would man up, for another better term here, block that law and stop this, what's happening throughout not only this area, but in the surrounding towns throughout the state, they will be venerated, because most of the residents here, I don't think takes brain surgery, are against the changing of this law. They like the town the way it is. They're happy to have people practice their religion the way they want to, in enough facilities that are already generated here. And if it stopped right here, it could be held up as an example to other towns that they too could block what looks like a conspiracy to change zoning laws to benefit one particular group. Doesn't matter what they practice and how they practice. It could be somebody that wants to put landing pads for spacecraft because they believe that's a religious obligation, or following some ancient religion, which is fine, but the facilities that they have now should serve for it without changing the law. And look at that as a possibility 5 or 10 years, and this board will have a fine, fine legacy. That's it.
Thank you, Mr. Perry. Mr. Wasserman, Jeff Wasserman.
Good evening, Jeff Wasserman, 365 South Pascack Road. Mr. Mayor, trustees, residents, and guests, thank you for your attendance this evening. This truly is a demonstration of democracy in action, and I'm thrilled to be a part of it and to have an opportunity to address you this evening. I'm speaking tonight as a resident, but in full transparency, I am a member of the Chestnut Ridge Planning Board, and I am also a candidate for village trustee in the March 19th election, which is 9 weeks from today. I'm not going to discuss specifics of the proposed amendments to the zoning code this evening, The village board has my response as represented in my comments and recommendations the planning board submitted on May 29th, 2018. Those comments apply to the initial draft shared with the board, but it's unfortunate the planning board has not been asked to review any subsequent revisions, especially when they were significantly more than just a few tweaks. While the Board of Trustees was not obligated to solicit the planning board's review of the revisions, the scope and nature of the proposed law and the subsequent revisions warranted doing so, in my opinion. I'd like to share 3 observations related to the proposed text amendments. 1, the village has never discriminated against religious applications and has never had an RLUPA challenge. In my 5 years on the planning board, I have worked with 3 applicants wishing to build houses or places of worship. That's 3 in nearly 5 years. RLUPA has not been adequately tested in our village, and so I do not see the need for the extent of the proposed amendments. Our land use boards have received training specific to handling applications for places of worship, and we have qualified counsel to help us make sound determinations with our existing laws. 2, the applications that have come before the planning board have all included provisions for on-site parking. These include Congregation or Mordecai at 2 Madeline Terrace, an application for what I consider to be a residential place of worship, which is proposed on 0.63 of an acre in a residential district, and they're requesting 16 on-site parking spaces. I believe this applicant and all applicants recognize the need for on-site parking, and this requirement should not be removed. The planning board worked with Mordecai and applied guidelines outlined in our LUPA. The applicant satisfied the board to the extent that we referred them to the zoning board for variances. The ZBA granted Mordecai 10 variances on November 24th, 2015. This clearly demonstrates deference to religious institutions and a willingness by our land use boards to work with them. I anticipate Mordecai will be back in front of the planning board to seek preliminary site plan approval. This is a clear example of how our land use boards are working with religious applications to attain their goals without violating our LUPA. 3, my third point pertains to the Orthodox Jewish Coalition, or OJC, which was the sole organization that lobbied the board for the law. I'd like to submit a transcript of a voice message from a representative of the OJC. The caller stated, quote, "The update to the House of Worship law is extremely detrimental to what we, the OJC, have been trying to accomplish. I don't think this can even work for what we are trying to accomplish, and therefore, we are back to the drawing board." That was October 18th, 2018. Based on these 3 points, I have 2 requests for Mayor Presti, Trustee Cohen, Trustee Miller, Trustee Valentine, and Trustee Van Alstine. 1, since the village has not demonstrated a need for places of worship, a need for the places of worship law, and the only organization lobbying for the law does not like the law, I request the village board stop and start over by first conducting a comprehensive plan and holding workshops to seek dialogue and input from all residents of Chestnut Ridge. I agree, the village is changing. And I understand there may be a need for amendments, but I believe there's a better way to serve all the residents of our village than what you have demonstrated. And 2, to those wishing to either build a new place of worship or legitimize an existing place of worship, what are you waiting for? The village boards are open for business. Get together with your lawyer, your planner, your engineer, and formalize your applications. Meet with CDRC, planning and zoning. If you need a special permit from the village, apply for your special permit. Bring the full power of our LUPA with you. Let's sit down and hammer out a plan that works for you and that works for the village. I think you will be pleased with the process. The land use boards in the village of Chestnut Ridge are open and waiting for you. Thank you for your time. I'm glad to see that everyone here is as passionate about Chestnut Ridge as I am. Thank you.
Thank you, Mr. Wasserman. Next, Anthony Sherrod.
Anthony Shaw at 23 Milwaukee Drive. For transparency, I am also running for village trustee with Jeff on the March 19th election. My focus tonight will be on the importance of a comprehensive plan. The facts behind the origination of this proposed law, as I understand them, are that the mayor was approached by members of the Orthodox Jewish Coalition and lobbied to draft the form of the law that residents were initially presented with early last year. From what I've been able to gather from speaking with various members of the community over the last several weeks, including members of the ultra-religious community, the OJC is one group within the ultra-religious community that does not necessarily represent that entire community. What this means is that you, as the board, initially proposed a law that could drastically change the landscape of the majority of our village based solely upon the input of one group within one religious community. It was only after you drafted the law that you sought to obtain the input of the remainder of the ultra-religious community and the entirety of the rest of our community. Understandably, that remainder of the ultra-religious community has chosen to support the proposed law because the only other option available to them thus far is no change, and we all agree that is not a good option. What I've learned over these last several weeks knocking on doors and having conversations with residents of all backgrounds is that the overwhelming majority feel there is a compromise to be made. A compromise that does not circumvent the Zoning Board of Appeals process while also addressing the needs of our religious residents, and doing so in a way that retains the rural residential character of the village. It's amazing to hear that most of our residents in this community with diverse backgrounds and lifestyles actually want the same thing, and all I had to do to find that out was ask them. Why can't the village board ask these same questions in a polite, open forum without the weight of poorly drafted, drastic zoning amendments? So the question becomes, how do we reach this compromise of polite dialogue where everyone can participate? What is the way forward that takes the time to fairly address the needs and carefully weigh the concerns of all residents of this village? The answer is that it's time for the village of Chestnut Ridge to stop tweaking an antiquated code and finally develop a capital C, capital P, comprehensive plan. The Pace University Law Use Center was extremely helpful in providing an in-depth look at what exactly a comprehensive plan is and what purpose it serves. I will share two interesting perspectives provided by them, taken from the well-grounded publication authored by John R. Nolan, founder of the Pace Land Use Law Center. Number one, according to the 2008 survey of land use planning and regulations in New York State, 69% of New York's governments have adopted a comprehensive plan. Somehow, 7 out of 10 governments in New York think that a comprehensive plan is prudent planning, but none of our board members feel that way. Number two, the requirement that all land use regulations conform to the comprehensive plan reveals the wisdom of the legislature in urging villages to adopt comprehensive plans with citizen comment and support. Said another way, adopting land regulations that conform to the comprehensive plan provides significant legal protection for such regulations. How is it possible that something that provides a blueprint for the future development and preservation of the community exists and is enforceable in a court of law to alleviate your legal concerns, and you are completely ignoring this obvious solution? Going back to earlier public hearings, we sat and watched members of the ultra-religious community stand up in front of this room and talk about their love for the current landscape of this village. We saw those same residents memorialize in a letter the fact that nowhere near 90% of this village is needed or desired in order to practice their religion. Why then are we taking this radical measure of changing the landscape of the majority of this village when so many of us do not want this? You are proposing radical amendments to laws that no one wants or needs, and that has accomplished nothing other than dividing the village. Zoning laws are just that, laws. A comprehensive plan takes zoning laws a step further and taps into the needs and concerns of the whole community to develop a sound and inclusive foundation for moving forward, for progressing. That plan, that law, will serve all members of this village fairly and responsibly. We all want to move Chestnut Ridge forward, but moving forward cannot be done without a plan to do so. I strongly urge you to 1, stop further consideration and revision of these amendments, 2, develop and adopt that comprehensive plan, and 3, rely on this plan to be the legal foundation and vision document to guide the village into the future for all residents. Thank you.
Thank you. Mr. Averso, Tony Averso.
Tony Averso, 40 Wilshire Drive. I've spoken to you people in the past, and basically, nobody wants to bring up 3 Spring Hill Terrace, but there's a situation there, and the way you're going with this law or trying to pass what you want to pass, take that 3 Spring Hill Terrace, the parking situation, the congestion, day in and day out, and multiply it 10 times, 50 times. Have you ever taken an idea of what's going to happen to this nice place to live? I moved here 10 years ago, and I thought it was a real nice place to live. The congestion is going to be out of control. The parking situation is going to be out of control. You're proposing something, and there's no limits to what you're proposing. You're giving vague examples. Have we, I know you guys don't want to answer questions, but you've got a town, gentleman on the left, has there been a survey done on roads as far as traffic or anything along those lines? I mean, that's basically what's going to happen. Now, I don't know if it's going to be 10, it might be 100-fold. But, I mean, at 90%, it's a big percentage. And those are not my figures, this is what I've been reading and hearing. So, I mean, you got to look at the whole picture, not just a little picture, because the little picture becomes a big picture. It's like picking up a dime on the floor. If you pick up 10 of them, you got $1. You're going to have $10 by the time you guys get done with what you're pushing through. Thank you.
Thank you, sir. Heather Fedenko. Heather Fedenko.
Hi, my name is Heather Federico. I'm at 30 Tartan Road in Mahwah, New Jersey. The reason I'm addressing this board tonight is I wanted you to know that what happens here with this decision is being looked at by so many other places in other towns. People in Mahwah, Upper Saddle River, Montvale, Woodcliff Lake, Woodbury, Monroe, Chester, Toms River, Airmont, Howell, Lakewood, and Jackson are going to be watching this. So I just wanted you to know that, first of all. I've heard a lot of talk about the First Amendment, freedom of religion, freedom of speech, freedom of the press. Well, there's also the freedom of assembly and the freedom to petition your government. In Mahwah, our government wasn't doing what we wanted them to do. And we decided, a small group of people got together and decided to recall the mayor. Everybody told us this could not be done. It was only 80 people that got together, and in all reality, about 20 people really worked hard on this. They had to get 4,100 signatures. They had 120 days to do it, and they did it. They put it on the ballot in June, and he was recalled in November. Now, I know New York State does not have a recall, but that does not mean that you do not have the power to talk to your neighbors and to ask them to vote and to tell them what's going on. A lot of people don't know. We didn't understand how many people didn't know what was going on in our town. And you know somebody, they know somebody, they know somebody. You just go knocking on the doors and tell them what's going on. And you know what? Come the next election, the people who are not doing the right thing can be pulled out of office, and people who will do the right thing can be put into office. press was against us. They laughed at us. They told us that this would never be done, and it is a success story. So I just wanted to give you a little bit of hope. And you guys are doing a great job, and we're rooting for you.
Just a footnote, MAWA is still under the supervision of the Attorney General of the state of New Jersey with any zoning ordinances they need to pass for the future. But thank you, Ms. Federico. Next will be Linda Amon. Thank you.
Linda Amon, 311 North Highland Avenue. As my neighbors and I have been living next to a house of worship for the past 15 months, we have become quite the authorities on the impact these places can impart on a neighborhood, and that is why we read with great interest Part 2 of an environmental impact study that the village filed with the state of New York. As per the replies, the village does not think that this proposal will alter any of the land surfaces, does not think it will impact surface waters, does not think it will affect plants or animals by the loss of flora or fauna, does not think it will cause a diminishment of public enjoyment or cause a decline in the appreciation of aesthetic resources, and finally, they don't think it will result in an increase of noise, odors, and outdoor lighting. Even your own planning board has disputed many of your answers. In response to this, I asked the board, what world are you living in? My neighbors and I live in the real world. It is a new existence of looking out on a lawnmower that only saw service once all summer and can't fit into an illegally converted basement garage, a rutted lawn on which 14 cars park anywhere they want, causing a mud parking lot that is actually plowed when it snows, noise from the slamming of car doors starting at 6:30 a.m. and continuing to 11:45, garbage that blows through the yard, and because of the erosion you have allowed to occur, a lake with boats when it rains. Hey, wait, look closer. Those aren't really boats, just overturned milk crates and wood pallets floating among discarded plastic bags. I would like to remind the mayor and trustees that no one in this diverse community has ever been denied the right to worship. All we ask is that it be done in a manner that respects the rights of everyone in the community. We didn't purchase our homes to live next to a shanty town and refuse to do so because of your lack of code enforcement. And besides, how is it equitable that some houses of worship are required to spend thousands of dollars getting plans drawn up, obtaining the proper permits, and going through all required inspections, while other houses of worship are allowed to slide right into a basement death trap with no permits or inspections? If that isn't a form of selective discrimination, I don't know what is. I think those in the audience should know what they are up to if a problematic house of worship pops up next to them. For example, when they report they only have 49 members to fit the definition of being a residential house of worship, but really have way more. Will our two code enforcers be out in the street counting? Seems unlikely when we're told they only both work the same 3 days, allowing the village to go to hell in a handbasket for the other 4 days of the week. A definite lack of efficiency at its best. Month after month, you will get up in front of this board to tell them how your neighborhood's character has been horribly altered. And if you're astonished at the creative excuses from your teenagers as to why they haven't gotten something done, just wait till you hear what the board has to say. Mr. Mayor, Board of Trustees, and your representatives, I remind you that to earn respect, one must give respect. Therefore, the report of a possible closed-door meetings, the apparent attack of amnesia by your planner as to who was in attendance and what they discussed, The arrogance displayed by dismissing the May 2018 recommendations of your own planning board as to the detrimental effects of this proposal, the numerous excuses given when told of serious code violations, the apparent lack of interest displayed by the trustees when they arrived late to these proceedings, and finally the "you people" counter response to the opponents of this plan does not afford this board that courtesy. It only shows us that if past behavior is a predictor of future behavior, you have neither the ability or the interest in representing all of your constituents should this flawed proposal be enacted. Thank you.
Thank you, Ms. Allen. Jerry Lieberson, Mr. Lieberson.
Jerry Lieberson, 31 Midway Road. Tonight's public hearing is the fourth held by the board on the proposed places of worship law. I think it's time to take stock. In my view, these hearings have not been particularly constructive. Earlier hearings have been hampered by continued, though justified, resident anger and outrage over the unfair and unrepresentative process by which this board came up with the proposed law. There were no resident workshops, not even to explain the details of this complicated law with some simple Q&A. And the law was initially drafted, as we know, behind the scenes, with proposals submitted only by one outside organization, the Orthodox Jewish Coalition, and nobody else. Along the way, however, residents have submitted substantive written feedback. 635 residents submitted this detailed 6-page letter of opposition with critical comment on specific provisions of the law, including rebuttal of the mayor's remarks about our LUPA, comprehensive plans, moratorium, and property tax exemptions. Over 800 residents submitted a 1-page letter of opposition distributed by coupon. And last July, 639 residents from the ultra-religious community submitted a 1-page form letter in support, though few of them probably know that their one key request in that letter has not been incorporated at all into the present law. So, what do we have after all this time, effort, and emotion? After 2 rounds of revisions, there is no complete and current draft of the law, just this mishmash of strikeouts and insertions to the revision that preceded it, which is also a mishmash of strikeouts and insertions that in turn can only be read with close reference to the original document, which remains the only ever complete draft of any kind of this law from a year ago. And this original document was not readily available to the village on the village website until shortly before the first public hearing last June. That is what this board has given residents to work with. Along with these hearings, which have been just one-way communications from the public to the board, without dialogue or debate, without any proper discussion of the serious opposing concerns that divide the community on this controversial proposal. The mayor has repeatedly justified this flawed law as necessary to avoid lawsuits. And yet, ironically, if this board votes to adopt these amendments as they stand now, it seems fairly certain to me and others that they will plunge this village into prolonged and serious legal action against it, and from what I have heard, possibly from both sides. Governance by lawsuit is not acceptable to the residents and taxpayers of this village. But it's not enough to throw these amendments in the garbage. The ongoing, unchecked, de facto expansion of informal, non-compliant places of worship has to stop. Existing places of this sort must come before the planning and zoning boards and follow the existing process. And what on earth do we do about the building inspector, who again and again is improperly interpreting the code, approving permits and plans without sending these properties to the planning board, even approving a permit when an applicant has appeared before the board but walked away from it without an approval of the site plan, and continually making mistakes that result in otherwise unwarranted variances and forced decisions by the zoning board. As Mr. Shout said earlier, it is time for the Village of Chestnut Ridge to stop tweaking and encumbering an ancient body of code and finally develop a comprehensive plan in accordance with New York State Village law. And I'm done. And frankly, folks, it is time to put new leadership on this board in the March 19th election.
Thank you, Mr. Davidson. I see we have another attorney here, Joseph Churgan. Mr. Churgan, you're up.
For the public record? Not quite as tall as him, but I'll try.
No problem.
Good evening, Mr. Mayor, and good evening to the board. Thank you very much for allowing me to speak to you. My name is Joseph Churgan. I'm an attorney, and I represent the Orthodox Jewish Coalition. I have been to several of these meetings, and frankly, a lot of the things that I've heard at these meetings have appalled me. I've heard attacks on the mayor that were unwarranted. I've heard attacks on the elected officials here that were unwarranted. I have heard attacks on our laws